or any court, tribunal, or any other authority for and against the organization or an institution, society, or corporation if he is a member of the executive committee of such organization, an institution, or society, or corporation. An advocate shall not act or plead in any manner in which he himself is pecuniarily interested. An advocate shall not stand as a surety or certify the soundness of a surety for his client required for the purpose of any legal proceeding. We are also having rule regarding duty to client. An advocate is bound to accept any brief in the court or tribunal or before any other authorities in or before which he proposes to practice at a fee consistent with his standing at the bar and nature of case. Special circumstances may justify his refusal to accept a particular brief. We are having rule regarding duty to opponent also. An advocate shall not in any way communicate or negotiate upon the subject matter of controversy with any party represented by an advocate except through that advocate. An advocate shall do his best to carry out all legitimate promises made to the opposite party, even though not reduced to writing or enforceable under the rules of the court. As I mentioned about this advertisement, we are having a rule regarding duty to colleagues. An advocate shall not solicit work or advertise, either directly or indirectly, whether by circulars, advertisements, touts, personal communication, interviews not warranted by personal relations, furnishing or inspiring newspapers comments, or producing his photograph to be published in connection with the cases in which he has been engaged or concerned. His signboard or nameplate should be of a reasonable size. The Indian Supreme Court and the High Courts have interpreted the various laws as enforced by the Bar Councils under the Indian Advocates Act and the Bar Council of India rules, and Supreme Court has delivered about 60 judgments interpreting the various aspects of the professional ethics, and the High Courts have delivered several hundreds of judgments, and therefore we in India have very evolved jurisprudence about professional ethics. I thank all of you for a patient hearing. Thank you.
Thank you very much indeed. The last speaker is Sam Twithgento, who is the senior partner of his firm, but perhaps he's going to answer all of our questions because he teaches advocacy and ethics at the Ghana School of Law. Sam.
Good afternoon, everybody. Well, I'm afraid much of the time has been taken because I've been worried that the opportunity that should have been given for us to dialogue is virtually being taken away, which is sad, because being given a lecture whereby you just throw it at people is not my concept. In teaching, I prefer dialogue with my students rather than merely throwing things at them. Now, the evolution of professional rules of conduct has moved from the point of broad principles and standards to more clearly defined rules in most jurisdictions. The author, Richard Painter, who is the leading author on this topic, has noted that in the first place, the shift may be those of broad principles that have been maintained. Secondly, he also argues that where the subject matter of a particular rule is controversial, the rules have remained as broad principles. Thirdly, he argues that the rules of professional conduct have moved from immutable rules of default, which can be altered by lawyers and their clients by contractual arrangements. This change, however, have occurred in the relation between lawyers and their clients, but rules governing the relationship between the lawyer and third parties have still remained governed by broad principles. The rules of conduct contemplated are those that protect the client, the rules that protect the third parties, the rules that protect the legal system itself. In my jurisdiction and the subject that I teach, we talk about this as the fourfold duty of a lawyer. That is his duty to the profession, his duty to the public, his duty to the client, and his duty to the court. Now, the duty to the court, of course, must be understood to appreciate that you appear before the court, and certain standards are expected of you. It's an obligation upon you, and if you flout any of those, there are consequences that flow from that. And I have served as a member of the disciplinary committee, and I can tell you we take it very seriously, because we disbar you if you flout those rules. So in addition to this principle of integrity, in addition to these rules, there are also principles of integrity, of honesty, confidentiality, and competence, which are enshrined in those rules. That means if you are incompetent and your client loses, consequences flow from that. Your client will sue you, but the client will equally bring an action against you before the disciplinary committee for you to be disciplined. Because I have also maintained to my students that you are almost like a surgeon who have professed to say that I can put you to death and bring you back to life. And if you are unable to do that, there is a price, and a very heavy price indeed, that you must pay. So, we notice then that codes and professional rules of conduct may vary in some jurisdictions, but there are international legal professional bodies such as the American Bar Association, the International Bar Association, the Council of the Bars of the Law Societies of the European Communities, the CCBE, the International Criminal Bar, ICB, just to mention a few, that have all drafted rules to reflect and uphold these principles. So the evolutionary shift from broad principles and standards to more specific rules governing the professional conduct, have been necessitated by rapid developments in the legal practice, and variations in the areas of practice generally, and differences in legal systems and traditions in the world. It is therefore expedient that these circumstances prescribe rules that are limited in their application. The flip side of the coin, however, is that in the day and age in which we live in, where there are multidisciplinary practices or multi-jurisdictional practices, we must begin to appreciate that the world is becoming like a global village. And therefore, technological advancements in information communication technology, multinational financial transactions and corporate practice, and developments in international criminal law and human rights have been all engendered discussion over the need for a uniform and standard to govern the practice of the profession the world over. So whether we want resource of globally accepted standard or domestic standard, there are challenges on both sides, which I wish just to touch on this. So globally accepted conduct is welcome in the idea in the development of the 21st century, which I have mentioned, because of the movement. We are now moving together and not shaping ourselves away from one another. Secondly, we need to appreciate that the Commonwealth itself, in its own evolution, meant that most people who practice law in the Commonwealth countries were actually trained here in England before they go back to their country. So they go back with the same standards as it was. True, we no longer exist as that kind of unit because most countries have their own legal institutions for training of their professional individuals. Nevertheless, we meet as a Commonwealth right here. And why are we discussing this topic? It is because we have this realization that there is a common bond, a common unity that's supposed to cement us together. And therefore, there ought to be broad general principles which are accepted by all of us, which will bind all of us. We also need to appreciate that in the old age, I think Stefan mentioned this, where judges and lawyers move from one country to the other. And many Ghanaians have gone to Zimbabwe and Zambia and East Africa to be judges, and Gambia. Now, they are not retrained. They just go there and they are judges. And many actually go there and practice law. Now, do we mean that when they go there, they must go back to school and learn new rules? And so it comes back to the issue, is it not necessary, is it not desirable, is it not that all of us should learn certain basic and general principles irrespective of jurisdiction in which we are practicing? We also need to appreciate that we are now even involving institutions, just like the EU has now, where you are saying that you are practicing in Europe, and therefore whether you are qualified in Germany or England, you can actually go there and set up a practice. You may not necessarily go to court, because sometimes we confuse ourselves. We assume that a lawyer's job is to appear in court. In this day and age, the majority of lawyers do not appear in court, but they practice law. And therefore, there has to be some principle that should govern law. And there is the need for the legal profession within the Commonwealth to begin to appreciate that there is the desirability and the need for us to learn basic standards of conduct and behavior that should govern our practice as lawyers. Thank you.
Thank you very much indeed, Sam. The fact that we've run beyond my targeted time of 5 o'clock for the speeches is really a tribute to the complexity of the issues that we have, and also to the tremendous efforts that our various speakers have made in making sure that they're equipped and ready to give their thoughts to this session. This is now your moment to ask any questions that you may have. If you would be good enough to first of all speak loudly, because there are no microphones for the audience, and secondly, if you would give your name and position background, that would be most helpful. Thank you.
Good afternoon. My name is Leslie Patterson, and I'm from Zimbabwe. And I've got a question for everyone. In particular, we have representatives in the audience from the Law Society of Zimbabwe. Mr. Sternford Moyo is the past president of the Law Society of Zimbabwe, and there are other gentlemen here from the Law Society of Zimbabwe. The Law Society of Zimbabwe is an institutional member of the Commonwealth Lawyers Association, and I'm a member of the Commonwealth Lawyers Association through my registration as a legal practitioner and member of the Law Society of Zimbabwe. I've been a member of the Commonwealth Lawyers Association since 1996. I have a question which is not only for members of the Law Society of Zimbabwe but also for members of the Commonwealth Lawyers Association and officials. The Law Society of Zimbabwe has physically assaulted and removed me from Law Society of Zimbabwe meetings, and yet it has not sought to remove me from the Commonwealth Lawyers Association physically, violently, on the same basis, and I find this fascinating. I have been told verbally by the Law Society of Zimbabwe that I'm not a member of the Law Society of Zimbabwe because I've been deregistered, and I think I should make it very plain at this meeting that the purported deregistration which the Law Society of Zimbabwe refers to is a purported judgment against which I'm appealing. And there's a piece of legislation in Zimbabwe which says until my appeal is heard by the Constitutional Court of Zimbabwe, I remain a member of the Law Society of Zimbabwe. Now, Mr. Moyo talked about why right and wrong should be the same everywhere, whether we're in Harare or whether we are in London. And I just challenge him and everybody here to say, if that is the case, why doesn't the Law Society of Zimbabwe and the Commonwealth Lawyers Association, who have been informed of my situation, do not act the same way in both jurisdictions? If you want material on this, I have material on this. By the way, the Law Society of Zimbabwe is attempting to deregister me because I have helped save from death row the first woman ever in Zimbabwe to be released from death row. Her name is Sipilile Kachiparo, and today I'm helping to save a black war veteran from death row by a former official of the Rhodesian government called Judge Smith. And if you'd like to know about